conditions, restrictions, master deeds, and things like that. And I advise some homeowners associations. And I also have sat on at least 20 boards of directors over the years. And I'm currently on the board of directors at 656 Coleman. Over the years, I've kind of come to the conclusion that this is really a thankless job, but it needs to be done. And so as you do the job as a member of the board or an officer, you're really doing your neighborhood a service. It's kind of the microcosm of what we see in public life, but generally more honest, in my opinion. We have our neighbors to answer to. We have obligations. We have a moral obligation to do our jobs in a way that's best for our constituents, not for ourselves, not for our friends. We don't bend the rules for our friends. The rules are the rules. The rules are for us as well. And if we do that, we're setting the proper example for the people that come after us on the board. So if you ask yourself when you're sitting on the board, why have I subjected myself to this? The answer is because hopefully you're there not to grind your own axe, but to do something for the neighborhood. So you volunteered for it. Examine your motives. Why am I here? Well, I'm here to do the job for the homeowners association, not for me. What are my ethical obligations? Well, you're not supposed to self-deal for yourself. So if you've got a cousin that has a roofing company, you don't steer the business to him. You don't show him what the other guys are bidding. Now, this seems like common sense, but I see it way too often. Matter of fact, my rule is I don't do business with my relatives if I'm on a board of directors. I just don't do it. I don't steer my friends to it and say, well, I know my friend does nice roofs. I don't do that. If he's in there, let him bid, or she, but don't give an edge to anybody. You wouldn't want it if you weren't on the board. And I'm not trying to lecture to you. I'm just trying to tell you the things that blow up in your face, because that would blow up in your face. So when you're on the board, one of the things that's the biggest problem is, my neighbor is violating the covenants in such and such a fashion. What do I do about it? Well, you guys have hired AMCS, presumably, and so they're the bad guy. You're not the cop. And they are trained to deal with problems. But if you do your best to keep things from being personal within your neighborhood, you're going to be a lot happier, and so are your neighbors. They're not going to show up at the next meeting with pitchforks and torches. They may be upset at AMCS, but AMCS is good at handling these things. I've known, gosh, Helen, I've been working with you for 20 some odd years, more than that. And with AMCS, I think their first client when they started in business in Sneed Farm Lake. So we've known each other, and I have always relied on my homeowners association management company to do the tough stuff. I mean, we have to support them and remember that they serve at our pleasure as board members. So we find out what they're willing to do and what they're not willing to do. And I think that they serve as an additional moral compass to us on what needs to be done. They don't have an interest in seeing us do wrong. They have an interest in seeing us do right. It's less problems for them, less problems for you. So I use my homeowners association management company pretty much like a rented mule. I don't want to be the one that tells my neighbor that trash goes out no earlier than 6 p.m. on Tuesday night, and it must be back in their garage, which is where they have to keep it, by 6 o'clock the next day. I don't have to do that. If they don't do it, they get a $50 fine. It's automatic and it's by the day. So if you establish a relationship with your management officer, they know what your lines in the sand are, and they will enforce that. And it's not personal. And that way, your neighbor doesn't have to wave their fist at you and say, why did you do this to me? You didn't. All you did is have instructed the homeowners association management to follow the rules and regulations that you've established. If you do that, then I suppose you could say, not my monkey, not my circus. You signed up for this when you read the covenants, conditions, and restrictions. And that brings up a very important point, I think. I have found over the years that probably 20% of the folks on boards of directors for homeowners associations have read the covenants, conditions, restrictions, master deed, rules, and bylaws. Sorry. That's a moral obligation. That's something you're supposed to know. And so make sure that you and your cohorts on the board are very familiar with the covenants, so that if somebody comes to you with a question, you're able to give a pretty good answer. You may have to say to them, this is what I believe it says, but I will look into it for you. And I have found way too many board members that get elected and think, okay, well, I'm elected, we've got a management company, that's the end of my obligation, I sign the checks. And that's not the end of it. So if you're knowledgeable, you can see things coming, perhaps to a head earlier. And so I've always tried to tell my board members, please just read them over, understand them, and make sure when a property changes hands that there's something that the new buyer gets when the management company sends out. There's a form that they send out that shows, and I think AMCS has been doing this for a long time. They send out a form that says, these are your dues. This is what the transfer fee is. This is this. And here's a copy of the articles, or you can get them online at our website. I know that they have a website for all of their, at least I'm sure they do have for all of their various communities. In that, there should be particular care taken that if you have a limitation on the number of rentals in your homeowners association, in order to make sure that you keep your financing in proper state when people are buying homes, if you have that limitation, make sure that that's something that gets sent out to the prospective buyer at the closing, because if they're buying it and they're expecting to rent it out, and oh wait, you already have reached the quota of the number of rentable units within your subdivision, that's a problem, because they get in there, they don't know it, they rent it out to somebody, and then you've got a sticky situation. So that's something I think to be clear about. Similarly, if you have a prohibition of Airbnb and VRBO, then you really need to make sure that people know that coming in, because you don't want somebody to buy an investment property expecting to make $250 or $300 a day when they can't do it, because that becomes potentially a lawsuit. So I think that that's something that has evolved recently. It wasn't as important before, but it is very important now. This is the kind of thing that we see coming up all the time. What is the very most important thing for you to have? Directors and officers in insurance, liability insurance. That's why, as an attorney, I would never practice law without errors and omissions insurance. You folks want directors and officers insurance, and you want it to cover litigation costs if they have to defend you for some decision that you've made that may or may not have been well advised at the time. Maybe it has been, but it gets litigated. I can't emphasize too much that if you're going to scrimp on anything, don't let it be the coverage for you who are doing this without pay as volunteers. You want protection. So that's something that I always want to underline for folks. In some instances, it's common sense, but I get a lot of people say, why do I need that? Why do we have to spend that money? More often you get it from people who are not on the board. Why did you have to spend this money? Are you planning on doing something wrong? Well, the answer is, for people like you, is the reason we have D&O insurance. You're the people that come after us. So make sure that you're doing that. Check, always also shop it. At least every 2 years, shop the cost of it, and make sure that you're getting some advice as to what the limitations might need to be. We see some people that are carrying $100,000 worth of D&O liability. That's not enough, particularly if you're doing construction. If you have a construction project going on and the board makes decisions about, well, we're going to do this, we can't do that because it's just too expensive, and then all of a sudden something bad happens, somebody sues you, you'll be named as individuals potentially, and you want to make sure that the insurance is in place and that it has sufficient limitations on it that give you a feeling of comfort. if your development is falling apart. Now, I've talked to Helen, and I understand that all of your developments are in pretty good shape right now. Some went through some litigation. I think also some of them have gone through the construction phase, and that's great. But if you run into a situation where you've got really cataclysmic issues going on, didn't know it was there, and all of a sudden it's right in your face, it's important that you exercise your best care in choosing the people that are going to advise you on what work needs to be done. And I'm sure choosing the attorneys that, and by the way, I don't do this kind of work, but choosing the attorneys that will be representing you. And, I think that you can talk to other homeowners associations that have had successful treatment, and you could talk to those that have not and figure out who the right representatives are for you. But again, you're making some big decisions if that happens. And the subdivision that I live in, 656 Coleman, we just achieved an excess of $8 million settlement for construction defects that happened as far back as 2008. And it's only 54 units. And the attorneys did a great job. It was a 5-year battle. And we have just this last month finished all the reconstruction stuff that we needed to do. Nobody's come out and said we didn't make a good decision, because I think it's pretty obvious that we did. But what if we pick somebody to run with the ball and they just fall on their faces? Somebody's going to be looking at the board of directors again. D&O. Am I saying that often enough? Directors and
Yes,
officers, please. I have a little cheat sheet for myself here, and I apologize for looking at it every once in a while, but I don't have a teleprompter like some of the politicians do. Let's talk about meetings, and we're going to have a question and answer period, if you like, after this. So, I'm touching on a bunch of stuff, and I want you to feel free to ask questions. We're going to have time to do that. But let's talk about homeowners associations member meetings, not like we do with board meetings. Board meetings, there are a lot of different ways to do board meetings. And some of them say, we're not going to have an open board meeting unless somebody requests it. That's what we do in my HOA. If you want to have a meeting, we have a meeting. Otherwise, the board members are constantly meeting with each other, and formally we meet every quarter, because there are just so few buildings in our subdivision that the three of us, and there are just 3 people on the board, bump into each other almost daily. So all the stuff that's going on, we talk about. But if you have board meetings, you're going to have to figure out something that makes people happy. And my feeling is, unless somebody has something to say and tells you about it ahead of time, I don't like to see board meetings mandated unless it's that way in the homeowners association documents, in which case you can do a Zoom meeting. You don't have to all get together in the same place. But the board meetings are one thing, but when you get to the annual meetings for the homeowners association, remember what you're doing. You are running a business. This isn't the place to get together and everybody's chit chat. I don't believe that any homeowners association meeting that my HOA has, or the one that I ran before that, has ever lasted more than an hour. And that includes when we elect people. If you can't get it said in an hour, then everybody's talking too much. Say what you need to say, go over the budget. This is what it is. Answer the questions from the floor and vote. Vote on the potential members as soon as you can for the new board. Get it out of the way. And then if there are questions after that, you can say, if you have any other questions we haven't covered tonight, feel free to contact me by email or some other way, or contact our management company. Management company is going to be there to make sure that you have a quorum and you get that right out of the way, and you get the minutes out of the way. So honestly, unless you're in the middle of a big construction program, or unless there's some other traumatic thing going on, you should be able to get in and get out. The longer those meetings last, in my experience, the more likely there will be to be some hard feelings when the meeting is over. Somebody's not happy. Keep it short and sweet if you can. And if you can't, there's always going to be that that time where you just can't do it, be polite. Remember, these people are your neighbors, even if they're crackpots. And I actually had one living next door to me. It was absolutely nuts. And we just tried to treat her with respect, and she's moved on, and that's good for her and it's good for the neighborhood. But in the meantime, we never wanted her to feel that she was not comfortable. And I think that's something that we need to take a look at. And remember that we're not supposed to be taking these things in a personal way. Some homeowners associations, everybody's pretty nice to each other, but the wrong thing said at the wrong time can create animosity. So again, just remember, you're one of the group. The fact that you're on a board does not mean you're special. It means that you're maybe special in the fact that you're willing to put the time in, but you don't have any extra value compared to any of your neighbors. And humility goes an awful long way in a lot of jobs. And I think that homeowners association is a really important thing. Now, let's see, what else do I have here? Well, I've touched briefly on the things that have always been important to me. Communication and transparency is really important in a homeowners association. Every once in a while we'll hear about somebody absconding with the money. Well, the money should be going directly through the management company, so there should be no worry about that. And by the way, they have directors and officers insurance and liability insurance and probably bonds for your money. Your money's safe with them. It's when one of the people on the board gets a hold of it that you have to kind of wonder about it. So we want to make sure that, generally speaking, it needs 2 signatures on checks if it's that kind of a neighborhood. In our neighborhood, we only need 1 signature, but somebody has to say, I want to write a check to so-and-so. The president will usually do that. And she needs one of the 2 of us, the other board members, to say, okay. And that is when the management company cuts the check. We don't cut any checks ourselves. We don't have the ability. We don't keep petty cash. We don't do any of that. So I've been doing this for a long time. And so for me, it all comes together in sort of this glob. And if you have questions, I hopefully will be able to answer them, or at least give you my opinion, which is very prejudiced about a lot of things. So, you take it with a grain of salt. Helen, go ahead and see if there's anybody that has any questions. If not, we just go home early.
There you go.
Or at least I will.
If anybody has any questions, please use the raise your hand feature. We'll be glad to turn your mic on so you can talk, or you can go into the Q&A, type out your question, and I will read it. But again, we are a small group. That's what we enjoy doing with these sessions, so that we can turn mics on. Rick, while we're waiting, will you touch on recording of meetings? On 2 different levels. One is the board recording a session and how that needs to be handled. And then the second is if you have a homeowner show up to a meeting and they want to record the session.
Oh, fun. Nobody gets to record sessions officially in any board that I'm on. You can't turn on your camera. You can't turn on your phone. Generally speaking, when somebody does that, they've got an axe to grind, and I'm not going to sharpen it for them. Very, very simply. Okay. We do not record our board meetings ever. Even if somebody shows up for it, we take notes. I'm not a big fan of the in-your-face approach of recording. Now, sometimes, you'll get, for a meeting that you're going to have elections at, somebody will request it. If that's the case, I will say the management company will record, and we will make copies available online to you if that's something that you want. I've never really, I haven't had to do any of those types of things, frankly, Helen, since Sneak Farm Lakes days. Yeah. And we always had one guy that wanted to show up with one of those 80-pound cameras that he put on your back, and he always had something. We would not let him do it. we would go ahead and accommodate it. If it looked like people wanted a recording, we would do that. But I believe that the HOA and the management of the HOA needs to keep control over that. I don't know, Helen, what's your experience been lately? I mean, everybody wants to put everything up on TikTok or something. I don't know.
They do. We do not feel it is appropriate to do that in many cases. As you said, we take the minutes or the secretary does. If a board does insist on recording a meeting, we have a destruction date on that tape, and it's just to make sure that minutes are accurate, and then the recordings are destroyed after that. We, and upon advice with other legal counsel also, do not keep those open-ended.
Right.
Rick, can you explain the difference between executive session versus regular board meetings?
Well, yeah, the board is privy to things that our members may not be. It may have to do with one or more members that are doing something. And so we will go into executive session. In my board, of course, we're always in executive session because nobody bothers to show up. We tell them when we're going to meet, if that's the case. But executive session is something that does not get reported. Notes are not taken. It's a place where people can go into a corner or into a room and discuss the topics before them without having people listening in and drawing, let's say, incomplete or incorrect conclusions. Some might say without them drawing correct conclusions about what's going on. I feel that way about some town council meetings and things like that. I try to stay away from executive style meetings. If I can, I think it needs to be out there in the open. If there's a legitimate reason to protect somebody's privacy, or maybe we're talking about a bid on something and we don't want people to know what the bid is so that they can tell their brother that such and such bid is $1,000, go bid $999. And that I think is a legitimate reason for going into executive and having executive discussions.
Okay.
Does that answer the question?
It does. I'd also kind of like to add that when you serve on a board of directors, you are afforded the right to be able to discuss something as a board amongst yourselves without an audience. Yep. It is good to come back out or have another meeting and go over it in front of everybody. But when you're going through something controversial, and it doesn't have to, in my opinion, be a legal item or speaking of somebody's account, but when the board's bouncing things off of each other and trying to see where they're going to land on what needs to happen, they're able to have the privacy to do so.
I agree.
Yeah.
I think that, yeah, it really does come up a lot in nuisance issues. We've had 3 complaints about so-and-so, and that's something you want to take in the other room. And then maybe when you come out, you say, well, we have a resident that we discussed in there about something that's going on with him, whatever it might be. And we've reached a decision, and it's going to be handled in such and such a fashion, or we will handle it appropriately. And I think we will handle it appropriately is something that if it's said in the right tone of voice, people are okay with it. And if it's said in the wrong tone of voice, then nobody's going to be happy on either side.
Yes. Do we have any other questions? As Rick said, he and I have worked together for a long time, so he and I could banter back and forth about this, but we're interested in any questions that you may have, generalized, specific, so to speak, something may be happening in your association. If you think of something after today, please don't hesitate to reach back out to us. We'll reach out to Rick and have him give an answer for us. Rick, I'd like to thank you for your time today. A lot of great information that you've given us, and we hope to see you again soon.
Well, given the lack of questions, and I understand that all the people out there are very professional about this. They've done it for a while. They know what they're doing. I probably haven't added a lot to a lot of fodder for their thinking, but it's a pleasure to be. It's always great to see you, Helen.
Thank you. A lot of
Adios.
times